Is your landlord making your life difficult, showing up unannounced, threatening you, refusing to fix things, or trying to push you out? Here's something most renters don't know. A lot of what landlords do on a daily basis is actually illegal. Today, Plain Verdict is breaking down 5 things your landlord absolutely cannot legally do in the United States, and what you can do about it when they cross the line. By the end of this video, you'll know exactly where the law stands and how to use it. Welcome to Plain Verdict, where we break down the legal concepts that affect your everyday life in plain language. No law degree required. We've already covered whether your landlord can enter without notice and what they can do with your security deposit. Today we're going broader. 5 concrete illegal actions landlords attempt regularly, often counting on tenants not knowing their rights. Let's get into it. Number 1, entering your home without proper notice. We covered this in depth in our first video, but it belongs on this list because it's one of the most frequently violated tenant rights in the country. In almost every U.S. state, your landlord is legally required to give you advance written notice before entering your rental property, typically 24 to 48 hours, depending on where you live. Your home is your private space, even if someone else owns it. A landlord who walks in unannounced isn't just being rude. In most states, they're breaking the law. The only exception is a genuine emergency, like a burst pipe or fire. Showing up to check on things, do minor repairs, or inspect the property without notice doesn't qualify. If your landlord is doing this, document every instance in writing, send them a formal written warning referencing your state's specific notice requirement, and if it continues, contact your local housing authority. Number 2, retaliating against you for exercising your legal rights. This one surprises a lot of tenants because it's less obvious than the others. Retaliation occurs when a landlord takes negative action against you, specifically because you did something you were legally entitled to do, like complaining about unsafe conditions, reporting a housing code violation to authorities, organizing with other tenants, or requesting legally required repairs. Retaliatory actions can include suddenly raising your rent, issuing an eviction notice, reducing services like heat or hot water, or making your living situation deliberately uncomfortable. Here's the critical legal point. Most U.S. states have explicit anti-retaliation laws that make this illegal. And importantly, many states presume retaliation if a landlord takes negative action within a certain period, often 60 to 90 days, after you exercised a legal right. That legal presumption puts the burden on the landlord to prove their action wasn't retaliatory. Document everything, keep a timeline of events, and if you believe you're experiencing retaliation, consult a tenant rights organization in your state immediately. Number 3, refusing to make necessary repairs and maintain a habitable living space. Every rental property in the United States is subject to what's called the implied warranty of habitability. This is a legal standard that requires landlords to maintain rental properties in a condition fit for human habitation, regardless of whether it's explicitly stated in your lease. What this means in practice is that your landlord is legally required to maintain functioning heating and cooling systems, a weatherproof roof and walls, working plumbing and hot water, safe electrical systems, and freedom from pest infestations. If your landlord refuses to address serious habitability issues after being notified in writing, you have significant legal options depending on your state. These can include rent withholding, paying your rent into an escrow account until repairs are made, repair and deduct, hiring someone to fix the problem, and deducting the cost from your rent, or in serious cases, terminating your lease without penalty. The key in every situation is written notice. Always notify your landlord of repair needs in writing and keep copies of all communications. Number 4, discriminating against you based on protected characteristics. The Fair Housing Act is a federal law that prohibits landlords from discriminating against tenants or prospective tenants based on race, color, national origin, religion, sex, familial status, meaning having children, or disability. Many states add additional protected categories including sexual orientation, gender identity, source of income, and marital status. Illegal discrimination can take many forms. Refusing to rent to someone, applying different rental terms or conditions, providing different services or facilities, or making statements that indicate a preference or limitation based on protected characteristics. Even subtle forms of discrimination are illegal, like suddenly claiming a unit is unavailable when a protected class applicant inquires, or imposing stricter application requirements on certain groups. If you believe you've experienced housing discrimination, you can file a complaint with the U.S. Department of Housing and Urban Development, known as HUD, or your state's equivalent agency. Fair housing violations are taken seriously, and penalties for landlords can be severe. Number 5, attempting a self-help eviction. This is one of the most serious things on this list, and unfortunately, one of the most common illegal tactics used by landlords who want to remove tenants without going through the proper legal process. A self-help eviction is when a landlord tries to force you out without a court order by doing things like changing the locks while you're away, removing your belongings from the property, shutting off essential utilities like heat, water, or electricity, or removing doors or windows to make the property uninhabitable. Every single one of these actions is illegal in all 50 US states, regardless of whether you owe rent, regardless of what your lease says, and regardless of any dispute between you and your landlord. The law is absolutely clear. If a landlord wants to evict a tenant, they must go through the formal court eviction process. Full stop. There are no shortcuts. If your landlord attempts a self-help eviction, call the police immediately. This is not just a civil matter. It can constitute criminal harassment or unlawful lockout depending on your state. Document everything with photos and video. You may be entitled to significant damages, and in many states, your landlord could face criminal charges. So, what do you actually do if your landlord is doing any of these 5 things? The process is consistent regardless of which violation you're dealing with. Step 1, document everything immediately and thoroughly. Photos, videos, written notes with dates and times, screenshots of messages. Build your paper trail from the moment you suspect something is wrong. Step 2, send written notice to your landlord, email or certified mail. Clearly describe the violation, reference the relevant law, and give them a reasonable deadline to correct the situation. Written communication creates the legal record you'll need if this escalates. Step 3, know your resources. Every state has tenant rights organizations that provide free or low-cost legal assistance. Your local housing authority handles habitability and code violations. HUD handles discrimination complaints. Small claims court handles deposit and minor damage disputes. And for serious violations like self-help evictions, don't hesitate to involve law enforcement. You have more options than most tenants realize. To recap, your landlord cannot enter without proper notice, cannot retaliate against you for exercising your rights, cannot refuse necessary repairs, cannot discriminate based on protected characteristics, and absolutely cannot attempt a self-help eviction. These aren't suggestions. They're legal protections that exist specifically to protect you. Knowing them is the first step to enforcing them. If this video helped you subscribe to Plain Verdict, we break down a new legal concept every week in plain language. And if your landlord has done any of these 5 things, drop it in the comments. We read every single one.